seated. We'll hear argument in 240424 in re Oncor Electric Delivery Company.
May it please the court, Mr. Heidler will present arguments for the Relator. The Relator will have 5 minutes reserved for rebuttal.
May it please the court, in the litigation arising out of Winter Storm Uri, the plaintiff's gross negligence claims against the state's regulated TDUs turns on a threshold question of law. Should the TDUs owe common law tort duties to electricity customers in the circumstances of this case, where a severe winter storm covered Texas, creating a severe electricity shortfall that imbalanced the power grid and prompted ERCOT to order the TDUs to load shed or interrupt electricity service to customers to rebalance demand with supply and prevent the imminent catastrophic collapse of a power grid serving 23 million Texans.
So I think we understand your point about that, but they also have claims for what happened in the hours and days after that, right? Like why didn't the blackouts roll, which really isn't a subject that appears to be covered by ERCOT's order. I mean, I think everybody understands your position about you've got to, you know, if we're going to have a catastrophic grid failure that's going to put us in the dark ages for months, you got to shed load. But at least a part of their claim seems to relate to what happened after that. So could you address that?
Absolutely, Your Honor. Throughout the entire load shed event, our load shedding decisions were constrained by ERCOT protocols.
So what in the record shows us that ERCOT prevented you from rolling the blackouts?
So I think the question that you're asking goes to breach rather than duty. The question we've raised here is a duty question, and that's covered by Mission Petroleum. Is this a heavily regulated activity? And what we show in the record is that the industry, TDUs, and load shedding in particular are heavily regulated. And when we get into...
Well, but we know that's not enough, right? Because the tariff itself says that you're not exempt from liability for gross negligence.
Yes, Your Honor. So the tariff is a regulatory instrument promulgated by the PUC, and this court has made clear that the PUC does not have authority to make common law determinations. So the issue we're raising here is, does Texas law impose a common law tort duty on the TDUs in these circumstances? At most, the PUC in its tariff can say, we have provisions that limit your liability, and those provisions will not protect you if a court finds you liable for gross negligence.
Right, but that, I think the heavily regulated industry argument for no common law duty is out because the tariff says that doesn't have that effect. And so then we're just left with the common law, right?
Well, under Mission Petroleum, Your Honor, there's several things the court looks at to see, is this a heavily regulated industry, and does it provide the kinds of protections that the court looks for in a regulatory system to decide whether it makes sense to impose a common law duty. The PUC does not impose a common law duty. It can't. This court's decisions...
But it doesn't say there is no common law duty either.
Correct.
Is my point.
That's a question for the court.
The tariff is very clear about that.
Correct. That's a question for the courts, and the courts decide that question by applying the Phillips factors. And in Mission Petroleum, that's what the court did. The court applied the Phillips factors, focusing on foreseeability and likelihood of injury, and the court concluded the regulatory system contains sufficient protections for customers.
Why do we apply the Phillips factors in deciding whether there's a gross negligence duty?
Because a gross negligence claim requires an underlying duty of care, and the duties that the plaintiffs have pleaded are common law duties. And so a court needs to decide, is there a common law duty that forms the basis of these tort claims, the gross negligence claims?
So what do you say about our statement in Chan that the Phillips factors are only appropriate to be looked at if there's not any analogous precedent on point, and that the way you do the Phillips analysis is from a much broader perspective than the facts of this particular case?
Yes, Your Honor. So our no-duty argument is based largely on the regulatory system. Utility code provisions, PUC regulations, ERCOT protocols, especially in the context of EEA3 load shedding. Those sources heavily regulate us, severely constrain what we can do. They also provide remedies to customers, impose administrative penalties, all the things the court looked for in Mission Petroleum when it decided not to create a common law duty.
But you didn't seem to want to answer my question about what it was in those regulations that prevented you from rolling the blackouts.
Okay, I'd love to answer your question, Your Honor. If you look in the bench book on tabs 4, 5, and 6, I've included some of those regulations. Throughout this entire period, ERCOT's load shedding protocols restricted TDUs, restricted what we could do. They required us to maintain service to nuclear plants, to prioritize military, law enforcement, public health, communications facilities, to avoid shedding load on circuits that are equipped with under-frequency load shedding relays, and to comply with any order immediately without delay and in a time not to exceed 30 minutes. One of the big problems we faced, and the PUC and ERCOT have since corrected this, but one of the big issues was with under-frequency load shedding circuits. So let me explain that. Prior to any emergency, ERCOT's protocols and guides require the TDUs to take circuits that carry 25% of the ERCOT system load, at least 25%. So it's about a quarter of the grid, and equip those circuits with these under-frequency load shed relays. These are devices that are designed to trip the circuit offline if the grid's frequency decays to 59.3 hertz or lower. So it's there to protect the power grid. When we get into EEA3 load shedding, ERCOT restricts us from using those circuits, about a quarter of the grid, for the manual load shedding that ERCOT orders. What that means is those circuits, about a quarter of the grid, will always remain energized during EEA3 load shedding. So when we get into load shedding, manual load shedding, and the load shed obligation is sufficiently large, it becomes difficult, if not impossible, to rotate outages with the remaining load in a way that is safe for the grid and complies with ERCOT's load shed protocols. One of the things the plaintiffs say in their brief or their petition is, well, we left certain neighborhoods on for the entirety of the load shed event while others were subjected to load shedding. That's exactly what ERCOT's protocols require.
And as you pointed out, that does sound like a breach argument. Your duty argument is much broader and would seem to include a hypothetical situation where somebody, none of the people in this case, but just to be clear, but if you had utilities that were able to roll the blackouts and knew that not doing so would result in loss of life and were consciously indifferent to that risk, you would say there's still no duty, right?
Well, let me be clear. We do have duties. We have regulatory duties. The PUC...
You would say there's still no gross negligence duty.
No common law duty. If in real time, ERCOT monitors the grid, the PUC looks at what we're doing. If we are doing something that is not in our load shedding plan, that violates our load shedding plan, that the PUC thinks we can do something differently to protect the public. Remember, under Section 14001 of the Utilities Code, the PUC has broad authority to regulate our operations. The PUC can issue an order and tell us to do something differently. And of course, during Winter Storm Uri, the PUC knew exactly what was happening. So the PUC can govern what the TDUs are doing in real time with ERCOT's coordination in a way that courts and juries can't. So yes, if we're regulated in how we plan, we prepare load shedding plans, we're obligated to under the administrative code, emergency operation plans. The administrative code says those plans must include procedures for rotating outages. If we don't follow those requirements, the PUC can investigate and penalize us. If we get into EEA3 load shedding and we're not following our plan.
So really, under that view, the parts of the tariff that say you could still be liable for gross negligence and that force majeure is an excuse or just surplusage, because you would never get to those, right, as long as you're following what the various things that you just discussed, and if you're not, then ERCOT can impose administrative penalties.
It would be the PUC, but it's not surplusage, Your Honor. The tariff covers a wide variety of ordinary business operations. It also covers a wide variety of emergency situations. So you could have a car strike a utility pole, a line comes down. That could be an emergency where a TDU needs to interrupt electricity service to resolve the emergency. What we're talking about here is Level 3 Energy Emergency Alert, Level 3 load shedding, which comes with a much more robust set of intricate regulations. Some are technical, like the UFLS requirements. Some are social. We need to prioritize critical infrastructure. All of these interests are baked into the regulatory system when it comes to EEA3 load shedding. So if there's some other emergency that arises outside of that context, and we commit an act that someone says is grossly negligent, there may be situations where we could be grossly negligent. But when it comes to EEA3 load shedding, our obligation is to protect the power grid. And remember,
So is this, I'm confused about what exactly it is what sort of analytical bucket to put this in. Is this a preemption argument?
No, it is a
Because it sounds like a preemption argument.
It is a Mission Petroleum, Elephant Insurance, Phillips factors argument. We have a comprehensive regulatory system, and what does the court say in Mission Petroleum? There's a system, and it does three things. It heavily regulates the defendant. Well, here, everything that the plaintiffs complain about in their petition is heavily regulated by the executive and legislative branches of government through the PUC. The system also imposed administrative penalties for violations. Well, the Utilities Code and the Administrative Code are clear. If we violate any of these regulatory orders or protocols, the PUC can and does investigate and impose penalties. And we've cited the court to orders where the PUC has penalized the TDUs for shedding more load than ERCOT required, for shedding less load than ERCOT required, for shedding load too slowly. And when the PUC sets an administrative penalty, it looks at the very risks and harms that the plaintiffs complain about and that a court would consider: the harm to property, the hazard to health and safety, the need to deter future violations. And then the system also provides avenues of redress to aggrieved parties. A customer affected by load shedding can complain to the PUC. They can complain by the telephone. They can complain in a formal written complaint. The PUC will investigate, and it can impose administrative penalties. So when
Could I take you back 1 minute to what you said about UFLS? I think that provides a helpful explanation of why for end users other than sort of nuclear generating facilities or military facilities and such, why there was a sort of predetermined need to, leave the power on in this neighborhood but not that neighborhood. So I think I understand that, but what's your response to the idea that your circuits substantially exceeded the levels that ERCOT required? What does that mean in your estimation, and what's your response to that?
So ERCOT's protocols require us to reserve at least 25% of the ERCOT. So it's a floor, it's not the ceiling. We can go higher. We can protect the grid more than ERCOT requires. But those provisions are also entirely regulatory. If we violate them, the PUC can investigate and impose penalties. If they need to be changed, the PUC can change them. And in fact, after Winter Storm Uri, the PUC and ERCOT have changed those protocols to give us more flexibility in using those circuits for load shedding. The other thing is, I think the plaintiffs misunderstand how the protocols work, okay? If you look in the record, it's in the 750s of the mandamus record. The protocols require the TDUs before any emergency to equip, like I said, about a quarter of the grid with these under-frequency relays. And then when we get into manual load shedding, those stay on and we shed load elsewhere. And one point to be really clear about, the circuits we equip should have at least 25% of the ERCOT system load. That is the total demand on the system, okay? So they're equipped with these relays. We get into manual load shedding, what do? We shed load on other circuits. That has the effect of reducing the load on the ERCOT system. But these circuits that are already equipped with under-frequency load shed relays are circuits we cannot use. So as the load on the system goes down, the percentage of circuits dedicated to UFLS goes up. So it could start at 25%, and as we manually shed load, that 25% is going to be a higher percentage of the total system load because the load's getting smaller. After Winter Storm Uri, that's what the PUC changed. So the PUC now allows us to use some of those circuits for manual load shedding to avoid this problem.
I'm sorry to interrupt, but I just have a jurisdictional question kind of backing up, and that is, do you see any argument under Chaparral in that line of cases that PUC has exclusive original jurisdiction here?
Not on this issue. So
Can you explain that?
Absolutely. The plaintiffs have pretty carefully, we think, and strategically pleaded exclusively a common law tort claim premised exclusively on alleged common law duties, probably to avoid this issue of are they going to go to the PUC. So they filed their petition. We filed a Rule 91A motion saying there's no common law duty. As this court has made clear in all of its common law duty cases, Elephant Insurance, Pagyon, HNMC, Mendez, whether there is a common law duty is a question of law for the court to decide. And then in the exclusive jurisdiction cases, in Re Oncor, in Re Centerpoint, the court has made equally clear that the PUC does not have authority to make common law determinations. So the question before the court on this mandamus is purely a question of law. It is a question for the court. Now, if the court comes back and says there is a duty, you have to rotate outages every 12 hours or whatever, there might be other issues in the case later on that would implicate exclusive jurisdiction of the PUC, but it's not this one.
Why would the duty be to rotate outages every 12 hours? It seems like the question's just, do you have a duty not to be grossly negligent? And then, you may very well be right that that wasn't breached for all the reasons you've mentioned.
Well, it wouldn't be a duty not to be grossly negligent, because that would really not be, that would just be repeating the gross negligence.
Okay, well,
test.
let me rephrase that. The tariff says you should use reasonable diligence to provide continuous and adequate delivery of electric power, and Utilities Code 186002 says you have a duty to maintain continuous and adequate service at all times to protect health and safety of the public.
Yes, Your Honor. So those are regulatory duties. They're duties under the tariff. They're duties that the plaintiffs not only have not pleaded, but they have repeatedly disavowed pleading. So when we filed...
But why wouldn't those support a common law duty as well that's sort of coterminous or consistent with that?
Well, it's not, the plaintiffs have not alleged any breach of the tariffs. And when we filed our Rule 91A motion, the plaintiffs responded. They said, quote, the transmission and distribution utilities attempts to recast plaintiffs' common law negligence claims as sounding in contract rather than tort to argue that they are governed by tariffs. So the plaintiffs were very clear. They're not relying on tariffs. In fact, they say that later in their Rule 91A response. They say the filed rate doctrine, because we were invoking the filed rate doctrine, the filed rate doctrine does not apply to state law claims that do not implicate the terms of a tariff. And then they also say the selected case petitions, this is in the mandamus record 524, the selected case petitions do not attach any tariffs as exhibits, nor do plaintiffs cite to tariffs. The other thing is, the tariff duty that you just quoted wouldn't apply in this situation. If you read 313 of the tariff, it says, yes, we have a duty to supply continuous and adequate electricity service subject to all legal authorities. That term is defined to include statutes and regulations. And if you look in my bench book at tab 3, you'll see the Utilities Code requires the TDUs to follow ERCOT's protocols. So when ERCOT orders the TDUs to shed load, interrupt electricity service, we have to interrupt electricity service. At that point, we cannot have a duty to supply continuous and adequate electricity service. And I think...
Thank you, counsel. Any further questions?
Thank you.
Thank you, Mr. Heidler. We'll hear from the real party.
May it please the court, Ms. Saucer will present argument for the real parties in interest.
Before you get started, could you address my question about jurisdiction under Chaparral and whether or not the PUC is the proper place for this?
Yes, Your Honor. We are in agreement on that one point. I think the agreement is going to quickly end there, that there is no exclusive jurisdiction in the PUC. And in fact, this honorable court found as much in 2 cases in 2021 involving these same exact defendants, Centerpoint and Oncor. So in the In Re Centerpoint Energy Houston case that this honorable court decided in 2021 at 629 Southwest 3rd, 149, this court said, statutes and regulations generally requiring a party to act safely or reasonably do not substitute a legislatively imposed standard of conduct for common law duties. In Re Oncor, decided that same year, reported at 630 Southwest 3rd, 43, this court recognized that utility regulations informed the common law for decades and rejected the argument that customers' personal injury action could not be adjudicated in the courts. So this is settled law stemming from at least these 2021 opinions. We've also heard today, though, a theme that is contrary to both of those opinions and throughout these arguments. Over and over again, when confronted with the facts pled in the petitions, this honorable court has heard my friend at the TDU go back to the regulations, some of these are guidelines in these tabs, the regulations as an excuse for why there is no duty. This flies in the face of what this honorable court decided in the 2 decisions in 2021 involving these same parties. This court said clearly in those cases that the fact that you are regulated, and those cases involved Oncor and Centerpoint, two of the parties before this honorable court today, the fact that you are regulated does not take away your common law duties. If I may, Your Honor, Judge Matthews did not abuse the discretion of the MDL court when she denied the TDU's Rule 91A motions in which they demand carte blanche to commit gross negligence and intentional malfeasance, causing death and destruction throughout the state. It was not an abuse of discretion to ignore those motions. And what this honorable court has heard today, and a theme throughout the briefing, is simply to demand that Rule 91A be rendered a dead letter. The Chief Justice of the 14th Court of Appeals, writing for a unanimous panel, identified 8 categories of gross negligence that we pled in our complaints. 8 categories. And all of the arguments are a distraction, an attempted distraction from those categories.
What is your understanding of the status of your client's claims for tortious interference, conspiracy, negligence, and nuisance?
We no longer have those claims.
They were dismissed, but not by final judgment. In other words, can you still appeal that? I mean, have you conceded on? Because it was the ones that weren't dismissed that led to their mandamus.
That's correct, Your Honor.
Right.
That's technically correct.
But have you now in some way formally conceded? Because it does seem to me that if you agree that you have no viable negligence claim, that there is some relationship to that and whether you have a viable gross negligence claim. Because if you can't be negligent, it's pretty hard to be grossly negligent, at least the way the petitioner or the relators are arguing it.
That's an excellent question, Your Honor. So what we have decided to do is not to take the 14th Court of Appeals decision up on writ to this court. The 14th Court of Appeals did not say that there was no common law negligence claim. What the 14th Court of Appeals decision said was that the tariffs apply. And so what the 14th Court of Appeals decision said was that the tariffs do not allow you to go forward with negligence, but they do allow you to go forward with gross negligence. And you have, in fact, pled at least 8 different categories of gross negligence. So by not taking the 14th Court of Appeals up on writ, we're moving forward with those 8 categories. The Chief Justice, writing for a unanimous panel, has given us the blueprint that we are going to move forward on because we can win with those 8 categories. And the first one, I think, is very important in understanding why there is no excuse on this record for not rolling blackouts and for the other malfeasance identified in the petitions. And that first category is that these defendants decided who to cut power to and for how long. ERCOT said all of you collectively need to shed 20,000 megawatts of load. ERCOT didn't tell them who to cut power to, and this court identified in Lumen the ERCOT load shed orders as for rolling blackouts.
And their response to that, which I asked them about, was, well, maybe they didn't directly in that order, but there are all these other regulations and whatever, all other administrative things they're called that basically meant that they didn't have a choice.
Yes, thank you so much, Justice, for that question. And my friend identified tabs 4 and 5 of their exhibits as the excuse for why they did not roll blackouts. There is absolutely no proof on this record that anything in tabs 4, 5, and 6 are any excuse at all.
That's because we're only on 91A, right?
Yes, Your Honor, yes. And the second finding of the Chief Justice of the 14th Court of Appeals was that they had no plan. They had no plan.
But how would we even know whether they did or didn't if we're just looking at the face of the pleadings?
That's exactly correct. The pleadings are presumed to be true. I will add, though, that the pleadings are completely plausible because in these pleadings we have To describe the chaos, we've cited the Texas Tribune, we've cited the Wall Street Journal, and we've cited the 2021 FERC-NERC report. So yes, the pleadings are accepted as true, but also these are extraordinarily substantiated pleadings. So on this issue of how none of these are proven to have anything to do with anything, one example in the pleadings is a citation to the Texas Tribune quoting someone working for one of these TDUs saying, oh, we realized we cut off power to the natural gas suppliers. We'll just flip the switch back on, see what happens. This happened days in. That happened after my client Bernadine Edwards' mother had already frozen to death. They decided.
Help me understand why you're saying we shouldn't consider 4, 5, or 6. Are these not, do these not have the force and effect of law? Does they need to be proven? What's your position? Help
They
me.
need to be proven. There is absolutely no proof on
Don't
this.
these have the force and effect of law? Are these not binding orders on them by
They're-
regulatory bodies?
Okay, their guidelines and some of their ERCOT nodal guidelines, I do not believe they have the force and effect of law, but regardless.
Well, even if they did.
Even if they did.
It seems like your argument is factually these, at least under the pleadings as they currently stand, these would not have prevented them from rolling, these things in tabs 4 and 5 would not have prevented them from rolling the blackouts?
Yes, exactly. There's.
So, and we don't know because we're just on 91A.
Exactly. There's no proof that what they did was necessary to restore service to military facilities or nuclear facilities or any of this. And again, they were criticized for what they did. They were criticized, and we quote the criticism, by the FERC-NERC 2021 report. So the experts at the Federal Energy Regulatory Commission and the North American Electrical Reliability Corporation looked at what they did and how they did it and criticized them for that. So we not only pled it, but we are citing experts, independent governmental agencies in support of what we are claiming here. And then if I can go to.
So gross negligence, of course, means more than just really, really negligent. It means consciously indifferent. It's essentially they knew what they were doing was extremely risky and they didn't care. It's a morally culpable state of mind. And in your view, do you have to allege facts that would support that kind of a conclusion in order to survive Rule 91A, or do you just have to say they were consciously indifferent and that gets you past this phase of the case?
We have to allege facts, and we do allege
So
facts.
what are the facts that you would point to in your petition that demonstrate the really horrifically morally culpable state of mind that you're alleging was in play here?
They preferred some neighborhoods over others, and they knew it, and they did it on purpose. They said, they promised they would roll blackouts for 45 minutes, and instead they left, for example, Bernadine Edwards' mother to freeze to death, while some people never lost power at all. And they admitted, as quoted in the Texas Tribune, that when they wanted to flip a switch on, they could just flip it right on. They deliberately turned off the power to industrial users in the chain of the power supply. This was reported by the Wall Street Journal even. So they deliberately, they were in control of who they turned the power off to. These were their switches, and they did it. They were told in 2011 by FERC that in that winter event, they were told, and they knew, because FERC told them, so this is a decade before Uri, that what happened in 2011 was the power was cut off, and the paperwork was in order with regard to this power cutoff to Occidental for only 90 minutes. And that caused a substantial problem in the middle of this emergency. And FERC reported on that. Even though the paperwork is in order, FERC reported on that and said not to do it. They had a decade to not do it. And what did they do? As reported by the Wall Street Journal, they cut off power to the natural gas suppliers in the Permian Basin. As reported by the Wall Street Journal, they cut off power to Loving County, even though they know even in Manhattan on Wall Street that basically every industrial user in Loving County is an oil and gas production facility. Now, they say, well, the list wasn't in order. We specifically pled Oncor controlled that list. We specifically pled they all controlled the list, and they all knew who was or what was on the list. we specifically pled that on the 18th of February, Oncor just fixed the list. So they blame the list, but on the 18th, they added 168 names to the list, increasing it fivefold. So they had a decade to not do what they were told by FERC in 2011 not to do.
So all of that sounds like maybe a viable negligence claim. But what about how they decided? I mean, what is your theory about how they decided whose power to shut off or not? Sort of, dartboard, or do you have a theory that would suggest some animus here, that particular end user was targeted for some reason? That seems to me like it might get to gross negligence, but what you're saying so far sounds like a lack of ordinary care, maybe.
It rises to, we do not have a theory that there was some that they didn't like Bernadette Edwards' mother, and that's why they froze her to death for 2 days. We do not have that. But the standard for gross negligence is that their conduct viewed objectively from the standpoint of them at the time of its occurrence involved an extreme degree of risk, considering the nature of the risk and the probability and magnitude of potential harm to others, to which they had actual subjective awareness, but nevertheless proceeded with conscious indifference to the rights, safety, and welfare of others.
So conscious, I mean, I think we understand that freezing is an extreme risk, but what's the conscious indifference?
The conscious indifference is that they flipped these switches and they left them off. They said that these blackouts would roll for 45 minutes, and they could have flipped the switches on. They could have rolled the blackout so that one person has power for 45 minutes, and then another person loses power for 45 minutes, and it rolls, so that you don't have what we had here. They left the switches off for people for days on time instead of turning them on and then rolling the blackouts. They did that on purpose. They did that because they were consciously indifferent to people freezing to death. And again, we have quotes from it was reported that they decided days into this, we'll just flip the switches on the Permian Basin and see what happens.
They say they did that because the various regulations and guidelines required them to do it the way they did it, and you say that's a factual dispute.
It's a factual dispute.
And they haven't proven that. They haven't provided evidence to prove that.
There's no evidence to prove it. There is absolutely no evidence to prove it. They are asking that this court ignore the pleadings and the reasonable inferences therefrom in direct violation of the requirements of Rule 91A. So another example, if I can. Okay.
When there's a legal reason for a justification for their actions that's grounded in some legal obligation, isn't it incumbent upon you to allege facts indicating that they weren't acting for that apparently legitimate reason, and that this was all just a matter of not caring that people were going to freeze?
We have alleged facts that line up with the definition of gross negligence. We've alleged that they had subjective awareness of all of these things that they were told by FERC to do that they then did not do. They had subjective awareness that they promised rolling blackouts of 45 minutes, and they didn't do that. And because they didn't do that, people froze to death. We have alleged all of these facts that line up with conscious indifference to the grave risk that did happen throughout the state. So under the pleading requirements, a short plain statement of the facts, that we have more than satisfied those pleading requirements. They want to deny that they're grossly negligent, but that is simply inconsistent with what happened here. They did not act remotely reasonably. They did not turn the power on to people whom they knew.
And they did not care people were dying. I mean, that has to be that's what a gross negligence claim is in this case, that they did not care that people were dying.
Consciously indifferent.
That's what we were struggling with. the notion that the facts that you're describing could indicate that degree of just extreme indifference.
There was extreme indifference. They controlled the
I mean,
switches.
just so saying there was extreme indifference is not the same thing as pleading facts demonstrating, right? The
you're
kind
on-
of just extraordinarily, like, horrific, again, to use that word, mindset that you're talking about, where the people pulling these switches just didn't care that somebody was going to die. That's quite something to allege, and so we're looking for, factual allegations that back that up, as opposed to just the sort of conclusory label that they were indifferent.
So I guess the question is, did you plead, or are there allegations that they knew that by leaving these switches off that people could freeze to death?
Yes, we pled their knowledge in a number of ways, yes. I mean, it's not just a matter of pleadings. It goes back to the United States Supreme Court said in 1978 that if you do not provide continuous electric service, then that's a public safety issue. It's in Chapter 186 of the Utilities Code that if that continuous service is responsible for public health and safety. I think it goes, we absolutely pled that this is why they were supposed to roll the blackouts. Why did they say they were going to roll the blackouts?
Was one of the grounds for their 91A motion, I'm sorry, I don't remember, that you didn't sufficiently allege facts that would rise to the level of conscious indifference?
They had every kitchen sink ground in the world in their 91, I guess so. But the 14th Court of Appeals got it right. That list of 8 categories, which, by the way, the only way that I've heard that these defendants are defending this is to just simply deny the truth of the petitions. I haven't heard them actually say, we thought everyone was going to be okay if we left them in this cold without power for 2 days. Maybe they've said that, but I haven't heard them say that.
I think what they're saying is, we didn't have a choice.
There is no proof of that.
Well, I understand we're on 91A, but that does seem to be what they're saying, and maybe on summary judgment, both sides could, if we get that far, both sides would have some evidence of that. But it doesn't sound like they're saying, we don't have any excuse for this.
They're not
saying
denying
we were required by the whatever these are called, the
Nodal
the
guidelines.
procedures, the nodal guidelines
which
to do this.
do not apply here. If tab 5 says whenever possible, and their interpretation of whenever possible appears to be let hundreds of people freeze to death. I mean, that's a wishy-washy, that there's no proof that that prevented them from rolling these blackouts, or that it prevented them from hoarding too much power on the UFLS circuits in violation of ERCOT guidelines. Why did they do that? There's no proof to justify any of these things. And again, we are citing credible sources. Our petition is more than plausible. It's based on FERC-NERC. We're citing the Wall Street Journal, and we're citing the Texas Tribune. This did not have to happen. These individuals did not need to freeze to death. And there are also admissions from some of these officials that they badly failed their constituency.
Counsel, before you sit down, could you just hum a few bars about the force majeure provision, please?
Yes, so the force majeure provision does not apply for several reasons. First, it says they have to say they did not reasonably anticipate this, and they did reasonably anticipate this. And I'm out of time, but I could at great length explain why that 37,000 number is bad math. Second, they have to prove that they acted in good faith, and they cannot prove that when they preferred some neighborhoods over others. Finally, their argument that, and also they have to prove reasonability, they cannot prove that. And finally, their argument that somehow, some way, the gross negligence and intentional malfeasance carve-out does not apply would, frankly, that's an extraordinary argument that would put a lot of contracts in this state, to my knowledge, up for grabs were the court to adopt it. Because what they're saying is that even though the carve-out for gross negligence and intentional liability is in the introductory subsection, so it's in Chapter 5, Section 2, Section 1, is a carve-out for gross neg and intentional liability. And then it's repeated later with the phrase, nothing herein. And they're claiming that it needed to somehow be repeated a third time, even though it was in the introduction, subsection 1, and even though it was later with nothing herein language, it had to be repeated the third time somehow in subsection 4. I think there are a lot of lawyers, contract lawyers who do transaction work who would be shocked to know that if you have a nothing herein clause, that is rendered meaningless unless it's repeated every time in every subsection. So that argument as a contractor, it's a tariff interpretation argument, makes absolutely no sense. Did I answer Your Honor's question? Does anyone else?
Thank you, Ms. Saucer. Any further questions? Thank you.
Thank you.
Mr. Heidler, I believe you have 5 minutes.
May it please the court, let me start with the facts for gross negligence, allegations of gross negligence. What the plaintiffs allege, if you look at tabs 12 and 13 of my bench book, they allege that right before the storm, ERCOT was working with the TDUs to minimize outages. On tab 13, the plaintiffs allege that ERCOT ordered load shedding for the purpose of preventing grid collapse. So the only reason we are load shedding is to protect the power grid and protect
If there is a TDU out there that during this storm shed far more than ERCOT's guidelines required, or for longer periods than required, or in the wrong places than required, would that TDU have a legal common law duty not to act grossly negligent?
So the things you're describing have happened before, and we cited the court, the PUC orders adjudicating those issues. So that is something that the legislature has given the PUC the authority to adjudicate, created a forum, specified the remedies. That is a claim they can bring in the PUC. It's heavily regulated. Under Mission Petroleum, no, there would not be a common law duty for those types of claims.
Okay.
What's your response to the argument that Centerpoint and Oncor are against you on that?
Oh, I would point the court to Mission Petroleum. Centerpoint and Oncor are not common law duty cases. They're cases about whether the PUC has exclusive jurisdiction. Mission Petroleum is right on.
But the reason there wasn't exclusive jurisdiction is because there was a common law duty.
Well, the court, I have to go back and look. I don't remember the court analyzing the common law duty Phillips factors, doing that analysis in those cases. Where it did the analysis was in Mission Petroleum. And the regulatory scheme here, if you just look at this court's grant decision, where this court explains how the regulatory scheme governing TDUs operates, and you compare that to Mission Petroleum, the two fit together hand in glove. So Mission Petroleum says, here are the facets of a regulatory system that will lead a court not to impose a common law duty, and Grant goes through and checks them all off and shows you how each of those factors exists in this regulatory system. Let me touch on this issue of, could we have rotated outages? I think these issues do go to breach, which is not the issue we're dealing with. The reason we have these protocols in the record is to show that this is a heavily regulated activity. And if there's something that needs to happen differently, the PUC and ERCOT are well equipped to tell us what to do, to change the regulations, to fix it. And so under Mission Petroleum, we don't think that's a basis for imposing a common law duty when an activity is this heavily regulated. She said, we had no plan for load shedding. I'd urge you to look at the Turner petition, paragraphs 84 and 85. They do not allege that we had no plan. What they allege is we had no rational plan. We're required to file emergency operations plans with load shedding procedures. We take this very seriously. What they're saying is the plans that we created were not adequate for what happened during Winter Storm Uri. And of course we disagree with that, but it gets to foreseeability. So let me point the court to tab 11. Tab 11 has an excerpt.
Sorry, how is foreseeability relevant to the duty question?
Because what they're saying is we had no rational plan. We planned before the winter on what we're going to do in the winter. What she says is the plans you had were not adequate for the grid conditions during Winter Storm Uri. So leading into each season, ERCOT prepares its seasonal assessment of resource adequacy report, where it tells us what it's forecasting for this winter. And it has several different scenarios, but there's one scenario that's really important. It's ERCOT's extreme planning scenario, the worst of the worst. If everything goes wrong, here is what you should expect. And the plaintiffs allege in paragraph 76 that in ERCOT's extreme planning scenario, ERCOT predicted we could lose 13,953 megawatts of power generation outages. A really big number, but we have to plan for it. Now look at the next box. What really happened during Winter Storm Uri is we had 50,000 megawatts of power generation outages. That is 350% higher than what the grid operator, ERCOT, told us would be the worst case scenario. So we're not in the best case scenario, we're not in the worst case scenario, we're way over here. And they do not allege any facts to suggest that the TDUs should have known to plan for those circumstances as opposed to the worst case scenario that the grid operator told us to expect. Let me briefly touch on nuisance, because I'm almost out of time. The Texans for Lawsuit Reform have an excellent amicus brief on this, explaining why failure to mitigate a natural disaster cannot give rise to an intentional nuisance claim, and we agree with everything they say in there on that. The other point I would make is on the force majeure provision, she said it doesn't apply if we could anticipate the event. It doesn't apply if we could, it does apply if we could not prevent the event, and we had no way of preventing ERCOT's load shed order, so the force majeure provision applies, and it bars all of plaintiff's claims.
Any further questions?
Thank you.
Thank you, Mr. Heidler. Thank you to all counsel. The case is submitted. That concludes the arguments for today, and the marshal will adjourn the court.
Rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.